Ever wondered why so many U.S. visa applications get denied? A major culprit is Section 214(b) of the Immigration and Nationality Act. This piece of legislation impacts countless visa applicants every year. Today we're going to demystify this law and its implications. Section 214(b) is a part of the United States Immigration and Nationality Act. It states that every applicant for a non-immigrant visa is presumed to be an intending immigrant until they can prove otherwise. This means that the onus is on the applicant to demonstrate that they have strong ties to their home country and will return after their visit to the United States. A denial under Section 214(b) means that the applicant was unable to convince the consular officer that they have ties outside the United States that will compel them to return to their home country after their stay. The ties are the various aspects of one's life that bind them to their country of residence, including family relationships, employment, possessions, and intentions. Now, it's important to understand that there are several reasons why a visa could be denied under Section 214(b). Lack of ties to one's home country is a common reason. If the consular officer isn't convinced that one has significant reasons to return home, they might suspect the applicant intends to overstay their visa. Interview issues can also lead to a visa denial. An applicant must convincingly articulate their intention to return home. It's not enough to just say it. They must prove it with substantial evidence. Sometimes people fit what's known as an overstay profile. This is based on factors such as age, marital status, and employment status. If an applicant fits this profile, they might face more scrutiny during the visa process. Previous interactions with law enforcement can also lead to a visa denial under Section 214(b). A criminal record, for instance, can make it difficult for an applicant to prove they don't pose a risk to the United States. Student-specific reasons can also lead to visa denial. For example, if a student is unable to prove they have the financial resources to support their studies in the U.S., or if they can't convincingly demonstrate their intention to return home after their studies, they may face a visa denial. So, to recap, Section 214(b) of the Immigration and Nationality Act presumes every non-immigrant visa applicant to be an intending immigrant. To overcome this presumption, an applicant must demonstrate strong ties to their home country that would compel them to return after their visit to the U.S. Reasons for visa denial under this section may include lack of ties to one's home country, interview issues, fitting an overstay profile, previous interactions with law enforcement, and student-specific reasons. Remember, a visa denial is not the end of the road. It's possible to reapply after identifying the reason for denial and making necessary changes. The key is to prove suitability for the visa category and a compelling intention to return home. Thank you for taking the time to understand Section 214(b). It's a complex piece of legislation, but with a clear understanding, it's possible to navigate the U.S. visa application process with confidence.